What are the most famous double jeopardy cases? Imagine being tried for the same crime twice and feeling like your rights are being ignored. That's where the idea of double jeopardy comes in to protect you. It's a key part of legal rights for anyone accused of a crime. But some cases have tested these protections in surprising ways. Let's look at some of the most well-known examples that show how double jeopardy works in real life. One of the oldest famous cases involves Jack McCall and Wild Bill Hickok. Back in 1876, McCall shot and killed Hickok during a poker game. He was tried in a local court and acquitted. But later, federal authorities decided to try him again for the same murder. This case helped shape early rules about double jeopardy, showing that sometimes different courts or levels of government can try someone for the same act. Another notable case is Currier versus Virginia. Michael Currier was charged with theft and firearm possession from the same incident. He was tried separately for each charge. His defense argued this was double jeopardy, but the court said no. Because the charges were different crimes, separate trials were allowed, especially since Currier agreed to this process. This case shows how the law sometimes makes distinctions between different offenses. Green versus United States is a case where the defendant was first convicted of second-degree murder. He appealed, and during his retrial, he was tried for first-degree murder, a more serious charge. The Supreme Court ruled this was a violation of double jeopardy because it was essentially trying him twice for the same crime. This case emphasizes that trying someone again for a more serious version of the same crime can be unconstitutional. In Abadi versus United States, the defendant was convicted in state court for conspiracy. Later, federal prosecutors tried him again for the same conspiracy under a different law. The Supreme Court decided this was okay because state and federal governments are separate entities, called sovereigns. They can prosecute someone for the same act without violating double jeopardy protections. A more recent and interesting case involves Byron D. Law Beckwith. He was tried 3 times over about 30 years for the murder of civil rights leader Medgar Evers. The first 2 trials ended with hung juries, meaning no verdict was reached. The third trial resulted in a conviction. This case shows that retrials after hung juries do not violate double jeopardy. It also raises questions about fairness and how long justice can be delayed. Knowing these cases helps us understand when the right against double jeopardy applies. It protects against being tried twice after an acquittal or conviction. But there are exceptions, like separate charges, hung juries, or different levels of government. This knowledge helps you see how the law works to keep trials fair and prevent unfair repeated prosecutions. It's an important part of your legal rights that keeps the justice system balanced.